it is simply raised through the issue of shares. So if the company sells shares, it is only able to raise this share capital. So we looked at premium, and of course, how the premium is supposed to be maintained in a company. So what is the purpose of having to raise the premium? What is it actually utilized for? For example, eliminating preliminary expenses, for example, covering up for premium on redemption of preference shares. For example, in this case, having to cover up for any free shares that have been issued by the company, so they can get the amount from the premium and of course the cover for such. So we looked at the types of share capital, whereby we said we can be able to have authorized. So that is the capital with which the company is registered with at the registrar's office. So it is known as the authorized, sometimes registered, sometimes nominal, We said you can have issued share capital, you can have issued share capital out of the authorized, then part of it can be issued. So it's what we call the issued share capital. Subscribed for share capital, called up share capital, and called up share capital. So those are some of the types of share capital we looked at. Then we commenced also looking at the prospectus. So we said it is a notice or advertisement issued by the company inviting members of the public to be able to buy. It can either be shares or sometimes it can be the debentures of the company. It can be the debentures of the company. So we said part of the contents that will likely be contained in the prospectus, it will just be details relating or pertaining to that kind of an issue of shares. But of course, most obviously also, we'll be able to see the name of the company there. We'll be able to see the dates under which the shares will commence for people having to be able to subscribe. There'll be the indication of the different classes of shares in the company. In any case, for example, the shares have been issued at a premium, it will be indicated there. But apart from these contents, we say there are key reports that should likely be, for example, attached to these prospectus. For example, performance of the company in terms of dividends, like for the last 5 years, can be indicated in the prospectus. The reports pertaining to the profits and actually losses of the company. So historical financial performance in terms of the P&L and of course statement of financial position for the last 5 years. That report will be attached on the prospectus. And then of course, in any case, the company is having to raise the share capital to venture into a major project. So they'll have to, for example, also attach there a kind of like a special report on that prospectus. So it can be as part of the information that can be relied upon, in this case by a potential investor who is having to buy shares in the company. So we left at the point where we were having to look at a misleading prospectus. So we said a prospectus that actually contains misrepresentation of facts is what we call a misleading prospectus. So of course we left at the point where we were looking at the remedies. Remedies in case of a misleading prospectus. So remedies. Statements in our prospectus. So these remedies can be categorized into two. So you can have remedies against the company. Have remedies against directors, promoters, or experts. So you say the remedies against the company, so they can be the rescission of the contracts. There can be rescission of the contract. So the contract can be the rescission of contract or cancellation of contract of allotments, rescission of contract or allotments, contract of allotments. So we said also they agreed you can be able to sue for damages for fraud, and not damages for fraud. Damages for fraud. Then the last one we said damages for negligence. Damages for negligence. Damages for negligence. So where there is a failure of duty of care, and of course it can be proved there was that failure of duty of care, and of course a party incurred a loss, then they can action for negligence. So we are supposed to start at this point of remedies against directors, promoters, or maybe what experts or experts. So these remedies are available to a misled investor, whether he cancels or resigns a contract or not. The following person are liable to an investor for any misrepresentation in the prospectus. We have directors of the company at the time of the issue. Every person who authorized himself to be named and was actually named in the prospectus as a present or a future director. Every promoter, in the case it's a company that is having to be formed. Every person who authorized the issue of the prospectus, or we can have what experts. Experts in this case, for example, we can have the auditors. We can have in this case auditors, professional accountants. Or for example, in this case, just an expert who was actually involved. For example, you have to say there's a special report that can be attached to the prospectus. Maybe it was prepared by a specialized expert. So that expert, whether he's an accountant, a valuer, as long as he played part in the preparation of the prospectus, then he can be liable. He can be responsible for those misrepresentations. So he said, in the case, for example, the examiner asks you to indicate, you can indicate the parties, who can be liable, it can be directors, it can be promoters, then it can be experts. If they ask who are the experts, you can say, for example, e.g., auditors, professional accountants, or any other relevant expert who was actually involved in preparing these particular prospectus. So the liability of such persons or these persons include damages for misrepresentation and criminal liability. Criminal liability. So when you talk about criminal liability, then in this case it has been proved. For example, they have been involved in fraud. So fraud, it was a fraudulent misrepresentation. So damages for fraud. You have the damages for fraud. And in this case, those misrepresentations or facts in the prospectus, they were intended to defraud a third party. For example, in this case, maybe in this case, them ending up, those third parties ending up having to lose their money when they do the investments. So that can actually be proved, then this one becomes of a crime. It becomes a criminal liability. Fraud is a criminal liability. Fraud is a criminal liability. So it becomes a criminal liability. So an action for deceit to recover damages may be brought by a subscriber if he proves that he was actually deceived. He was actually deceived with the intention to do what? To be defrauded, So their intention was these investors invest their money, but of course, now in this case, what they are having to rely upon as information is not factual about the company. So if that can actually be proved, then the criminal liability of fraud actually arises, and of course, this investor will be entitled to recover any form of damages. When you look at damages, I already told you, they simply mean what? The losses that you've incurred. Damages simply means the losses you've incurred. For example, in this case, you spend money to invest, but your pesa imekunywa maji. So that case, it simply means that your pesa imekunywa maji, you can be able to recover it. The loss you can be able to recover. So damages for what? For fraud. In a case, it can be proved that their intention was to deceive this investor. So they are intending to defraud, kumwibia pesa in short. Kumwibia pesa. So kumwibia pesa ni kama sometimes unapatanga watu wameka investment schemes. The intention to do what? To defraud investors. So unaekelea pesa yako naambiwa ilienda under. So the money actually gets what? It gets actually lost. So that is what a fraud. That is actually a criminal liability. Damages for misrepresentation. The remedy is available for any loss sustained by a subscriber by reason of untrue statements in the prospectus. The subscriber must, however, prove that the prospectus contained an untrue statement or material facts and that he actually sustained a loss. So you can be able to prove there was a misrepresentation of, for example, in this case, a misstatement in the prospectus, then you can be able to do what? Maybe for these particular promoters, directors, or maybe experts to be liable. So, so we are saying generally in this case, directors will be called upon to be responsible. But in this case, the directors of the company, if you are a director of that company, say for example, if all of us were actually directors who are party to having to prepare the prospectus. But in this case, maybe one of us didn't actually play a very key role in terms of preparing these misleading prospectus. So this director, one of us can actually be able to defend himself, for example, in a court of law. So in the case, for example, you've been taken to a court of law as directors. So how will you be able, for example, to defend yourself? So you can see there, number one, he can be able to say he withdrew his consent to act as a director before the prospectus was issued, and that it was issued without his consent. So long as you can be able to prove that in this case, you withdrew your consent not to be party to that prospectus that has actually been issued. For example, you can make a public statement. You can make a public statement or come out publicly that me as a director, because I'm a director of this company, I happen to know there's a prospectus that has been issued, but of course, the members of the public should just be able to know that I'm not actually party to it. He was not aware of the untrue statements, and on becoming aware of the same after the issue of the prospectus, but before allotment of the shares, he withdrew his consent and gave a public notice. That the statement was in fact made on the authority of a competent expert. So you can be able to argue that in this case, that statement we, for example, indicated or included in the prospectus was made on the reliance of an expert information. So therefore, him as a director shouldn't actually be called upon to be responsible, because in this case, he doesn't have that kind of expertise. He doesn't have that kind of expertise. So he relied on his statement, and of course, in this case, ended up having to include it in the prospectus. So he can be able to defend himself by having to indicate so that the statement included in the prospectus was simply based on the reliance of information or advice of an expert. That the statement was from a correct and fair copy of the initial document and was based on the authority of an official person within the company. So it was, for example, this is a statement got said on the reliance of the information of maybe a finance manager. A finance manager, exactly an official person in the company. So the finance manager gave them the reports. So of course, he ended up having to make the statement by relying upon that official information from the official person within the company. So that's the idea what will end up having to happen in any case. For example, these directors, experts, or maybe promoters have been found to be responsible. Of course, we having to say a criminal liability will end up having to arise. In any case, for example, there's actually maybe a fraud that will likely happen. And of course, in this case, if it's a fraud, then the matter before the court will be between the state law office prosecutors and of course the defendant himself, the directors, who are the ones who have actually committed the wrong. So under criminal law or under criminal liability, so we'll have state prosecutors having to prosecute the matter. So in that case, there was that intention to defraud members of the public, members of the publics. So that's the what will end up having to happen. So experts are exempt from criminal liability. The following actions and omissions constitute criminal behavior in relation to preparation and issue of a prospectus. So failure to include matters that are supposed to accompany the prospectus. The prospectus, issuing a prospectus without delivering a signed copy of it to the registrar of companies, So that's what will end up having to happen with regard to misleading prospectus. So I want us to look at underwriting, commission, and brokerage. So sometimes in this case, the company issues out shares, gives out shares. So you say, for example, they can be able to issue out to the members of the public, let's say, for example, a million shares worth a million. But in this case, or we can say a million shares. So maybe each with a value of maybe 100 or 100. So they issue to the members of the public for the prospectus. But it happens only 800,000 shares are subscribed for. You can see the intention of the company was to raise share capital of this a million shares of 100 each, but they have only been able to get a subscription up to 800,000. So it simply means there's actually a gap of how much? 200,000. There's a gap of 200,000. So the company wouldn't have been able to hit or realize its targets. So what the company can be able to do, in this case, if they have subscribed for. So therefore, the chance or the room of having an under subscription won't actually arise. And of course, the company will be able to realize the target rate. Under subscription, they'll be able to take up what? The shares. Then sometimes the company, those persons who deal in shares to support them or maybe assist them in having to issue what? The shares. So they can involve what we call what? A broker. So they can go for a broker. In this case, they'll be able to pay this broker what we call what? A brokerage commission. Brokerage commission. So you talk about brokers, your stock brokers, they are simply persons who facilitate or maybe support the company in having to do what? Sell their shares. Sell their shares. So they'll actually be entitled to a brokerage commission. So you can do what we call a brokerage commission. So underwriting commission. So Grace, you can take us through what is underwriting commission.
A public which invites the public to subscribe.
Public company, sorry.
A public company which invites the public to subscribe for its shares or debentures must ensure that the issue is fully subscribed by the public. To ensure that this happens, it may pay an underwriting commission on all shares or debentures offered to anyone who guarantees that any of the shares are not taken up will take them up. Before paying underwriting commission, the following conditions must be fulfilled. Payment of the commission must be authorized by the articles. Commission paid or agreed to be paid does not exceed 10% of the price at which the shares or debentures are issued, or such lower rate as may be fixed by the articles. The amount and rate of commission and the number of shares to be underwritten must be disclosed in the prospectus if shares are issued to the public, and if not, to public disclosure must be made in the statement of prospectus.
Yes, it's statement of view. We say this statement of view of prospectus. Sometimes we call it what? Abridged prospectus. So the one that in this case you approach investors privately and of course you just give them the prospectus without having to go public like the normal what? Prospectus. So that's what we mean by underwriting commission. So there's that chance when the company issues out shares that there can be what? An under subscription. So therefore they involve what? An underwriter. What actually gives the assurance? In that case, these shares are not actually taken up. I can be able to do what? Take up the shares. Then brokerage. You can take us through one channel.
It is commission paid to persons who deal in shares and debentures and whose business includes procuring the subscription for the shares and debentures. Unlike underwriters, brokers do not undertake to take up shares or debentures which are not subscribed by the public. Brokerage must be paid to a broker for services as a broker and not to a person who induced the other to subscribe for the shares and debentures.
Yes, so that's what we mean by brokerage. So you can involve stock brokers. You know, these are some investors who are intending to invest. They can assist you having to what? Sell your shares. So they can support you to be able to hit your target. But of course, for them, they don't give assurance. They will take up what? The outstanding shares that are not actually being taken up. They don't give that kind of what? An assurance. They don't give that kind of what? An assurance. That kind of an assurance. So there's that rules governing application. So I want us to first of all to look at methods of issue of shares. Methods of issue of shares. Methods of issue of shares. I want us first of all to look at methods of issue of shares. So how do you issue shares? Which approach can you be able to utilize in having to issue the shares? Which approach can be utilized? So methods of issue of shares. Methods of issue of shares. So it can be what we call direct offer. It can be what we call direct offer. Direct offer. It can be what we call offer for sale. You can do what we call this as blessing. So the blessing is there. Then you can have tendering. So have blessing. Here. Then we have tendering. Offer for sale. For sale and tendering. Tender. Then you have what you call a rights issue. Another rights issue. And go for a rights issue. So direct offer is whereby the company directly is involved in having to buy the shares. So what happens? The company, through its directors, they're able to come up with the prospectus. The company through its directors, they're able to come up with what the prospectus. Then of course they invite members of the public to do what? To buy the shares. And then you have offer for sale. Offer for sale, these shares are issued, or basically these shares are actually sold to an issuing house that eventually undertakes the whole process of issuing of the shares. So the company is not involved directly in having to issue the shares. So they sell all the shares to an issuing house. In this case, it's just an entity responsible having to undertake what? Issue of shares on behalf of other companies. So they sell all the shares to this particular issuing house, and of course it does what? It subsequently prepares a prospectus, inviting people to do what? Buy the shares of the company. This one is advantageous because it does what? It tries to save time for directors. So they won't actually be involved in that tedious process of having to come up with their prospectus, all that. So this one is actually left in what? The issuing house. So it has that advantage, whereby now in this case, the time that could have been spent by directors, for example, preparing a prospectus, they can focus or actually concentrate on other matters pertaining to what? Running the affairs of the company. So that is what? Offer for sale. Then you have placing. Placing, still the same case. So the shares now in this case are given to an issuing house. So the company enters an arrangement with an issuing house. Then of course, what the issuing house does in this case, they'll be able to place the shares with investors within the economy who can be able to buy the shares in very huge blocks or very large blocks. So they actually simply maybe approach them and of course convince them to buy the shares of the company in very large blocks instead of having to wait for each and every investor in the economy. So one person comes, subscribes for 100 shares. These are the 200 shares. So they simply basically take the approach whereby they can go to corporate entities that do heavy investments in the economy and decide, for example, they convince them, they place the shares with them, and of course, they buy like almost 1 million shares. Instead of having to wait for one investor, 100 shares. Another one. So we have the contribution in this case having to be made by employees to NSSF. Approach this kind of an entity, which in this case they know most obviously, quite obviously, each and every month they get a lot of money. They get a lot of money from what? The employees, because there's that deduction eventually submitted to what? NSSF. So these ones are likely to do what? Buy the shares in very huge blocks because they have what? The money. Of course, they want to do what? Do the investments. And of course, in this case, so that when people retire, they can be able to get what? Some form of interest. So they can approach such kind of an entity and convince them that we can be able to place the shares with you. And of course, in this case, what happens? You buy them in huge blocks. So that's what we call what? Placing. Then you have tender. So tender in this case, bids actually invites. So the person is actually able to quote the best price. So the best price that the company intends to sell the share at is the one who will be able to do what? He sold the shares to. So the shares will be sold to that person who places the most favorable or the best bid on the shares. Then rights issues. When you talk about rights issue here, so you simply basically take the option of having to market, maybe in this case, convincing the already existing shareholders to do what? Buy the shares of the company. So you won't actually go out there publicly, but in this case, you'll be able to do what? Convince the already existing shareholders. They can be able to, for example, acquire or maybe buy more shares, maybe in proportion to the number of shares they already hold what? In the company. So you go for the option of having to give more shares, the already existing what? Shareholders, or actually convince them to get extra or more shares in the company. So those are the methods, or ways that in this case, shares will likely end up having to be issued in a company. So Grace, you can take us through number 1 and number 2.
Direct offer to public. This is done by publishing a prospectus inviting the public to subscribe for the shares. This is not by the public.
Feeling that right time. Then number 2.
Under this method, the company may sell the whole of the shares to an issuing house, which in turn publishes a prospectus inviting the public to purchase the shares that are higher price to cover for issue expenses. The company adopts this method, then it has the responsibility for the success of the issue, and it will now already have a binding contract whereby the issuing house has subscribed.
They are saying that that has got an advantage. How washauzia the issuing house. So vile watauza hiyo ni shauri yao. So they have to deal with it. They have to make sure they have pushed the shares have actually done what have already been sold. So we are seeing it saves time. So the directors won't be so much involved because even the prospectors prepared by the issuing house, everything concerning the issue of shares, shauri yao. So they can be able to, in this case, end up having to do what, maybe find a way they can be able to convince what the shareholders, or basically the potential investors, or maybe potential shareholders to buy the shares. So you can take us through number 3 and number 4.
Offer by tender. This is where tenders are invited and the shares are sold to the highest bidder. It is meant to ensure that the highest possible price is obtained and to discourage stocks who apply for speculative purposes.
That's blessing.
Yeah. Placing. In this case, the company arranges for the issuing house to purchase the securities and places them with its clients, usually in fairly substantial blocks. This method usually favors large institutional investors, indeed the necessary. Small investors are, however, protected in a way by the Securities Exchange, which requires such companies to make a substantial proportion of the securities available to the general public.
Yes, so that will be by placing. The issuing house takes up the share, but in this case, they target maybe their clients or those who can be able to buy the shares, but in very huge blocks. For example, they can be able to target maybe investment banks or maybe insurance companies. Insurance companies, they collect money. Then, of course, they invest on behalf of what? Behalf of those who are, for example, making the contributions. So they have, like in this case, maybe what money market funds or those ones. So those money market funds get the money, then of course they invest in this kind of investments. Maybe it could be shares, or maybe it can be what? Maybe in bonds in government, maybe bonds in government. So what happens under placing? They issue shares, then one answer to target. So now there's a more mingi sana in substantial blocks. So they actually convince such kind of their investors to be able to do what? Buy the shares. So don't you can take us through rights issue. You've seen it. Rights issue.
Yes. This is an issue of share with the company to existing members who are given rights to acquire shares in proportion to the existing shareholding. This minimizes flotation expenses and also the assistance of issuing houses is dispensed with shareholders who do not exercise their rights. In this regards, we'll have their rights sold to the open market.
We'll have their rights sold to the open markets. Yani, for example, if all of us are shareholders in a company, the company convinces us to get extra or more shares. Probably in this case, in proportion to the number of shares we already have in in the company. So the company doesn't go into these issues of having to, for example, do flotation to the members of the public or inviting members of the public. So they call upon us as members of the company to exercise that right, to exercise. You exercise by having to do what? Buy more shares. In the case you don't exercise, is when they can be able to go for that option, whereby they can, in this case, go to the public and call upon them to be able to do what? Buy the shares of the company. 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 So those are the methods. So don't forget about them. So these ones they can be tested. These ones can be tested. So you can be able to say I've been able to highlight. When you see the notes where I've been able to highlight, that is very key. That is very key. So these ones can be tested. The method of issue of share tests. They put there 8 marks. Explain 4 methods of issue of shares. So let us look at class shares and the variation of class. How does variation of class rights actually happen? How does variation of class rights actually happen? Variation of class rights actually happen. So when you talk about class rights, these are simply rights attached to a class of shares. When you talk about class rights, for example, we talk about rights of a member of a company, rights of a shareholder of a company. So when you talk about class rights, these are simply rights attached to a class of shares. And of course, you can be able to have different classes of shares in a company. For example, preferred shares, ordinary, redeemable, bonus shares, and bonus shares is correct. Bonus shares, employee, promoters or founders shares, then employee shares. Because it doesn't sema preference, ordinary, redeemable, preference shares, employee, founders, then tukasema bonus shares. So all these ones, for example, ukiwa ordinary shares, utakuwa these rights, you can be able to control the affairs of the company, you will be entitled to the residues of the company, all the residues of the company in terms of what liquidation. If you are a preference shareholder, in this case, you'll be entitled to get dividends for any other class. You get dividends at a specific rate. Those are what you are calling what rights. They are what you are calling what rights. So sometimes the variation of these rights you're having to talk about can happen in the company. Or these rights can actually be varied, So the company wants to vary the rights of a class of shares. The company wants to vary the rights of a class of shares. Because they can be able to proceed and do what as a distribution or actually agree that they are going to do what to vary the class rights. They're going to vary the class rights. But the members of that class of shares will have to do what? Approve of it. Will have to approve of it. So for example, in this case, if there are those ones holding, in this case, let's say, for example, preference shares. Because these rights are aware in the articles of associations, they are contained in the articles of association. So the rights which and every class of shares are contained where? In the articles of association. So let's say, for example, the rights of preference shareholders want actually to be varied. Or the rights of preference shareholders wants to do what? To be varied. So because the company will be able to pass that resolution, but in this case, they'll be able to do what? Vary the rights. But members of this class of shares, one hold preference shares, will be able to do what? Convene a meeting. So they should be able to convene a meeting. There should be a convening of a meeting of the members of this class of shares. Then at that meeting, they'll be able to pass. They should be able to pass what we call a special resolution. Special resolution for variation of class rights. Special resolution to determine inahitaji percent ngapi ya voting rights. 75% plus. 75% plus voting rights of the members of that class of shares should be able to approve of that what? Variation of what? Class rights. So once they have been able to approve, So of course we'll have like what the minority. So minority watakuwa ngapi? So tumesema 75%, 25, but kuna gap hapa inabaki ya wangapi? 25. So of course they can be able to approve, pass a resolution, give it to the company. Probably in this case for the companies to do what? Proceed and do what? The variation of class rights. But the minority, a minimum of 15%, minority, which is actually a minimum of 15%, will still have a right to petition for the rights not to be varied. So remember 75% were sharp to pass the resolution. Labda imepelekwa kwa kampuni, so it has already been passed to the company to make the effect. But the minority who are 15% plus can be able to object to the variation by petitioning the court. What do you mean by having to petition the court? They simply give reasons to the court as why in this case they want the rights under that class of shares not to be varied. So they petition the court. They give reasons, but in this case they don't want what our rights to be varied. So in any case, the court listens to such kind of a matter because they are reasonable. The reasons they have been able to give are very much reasonable. The court can object or stop the company from having to vary the rights. So in this case, the minority in that class of shares still have a right. So for example, this case, do what? Object to the variation by petitioning the court, by presenting reasons before the court. And in this case, the rights of that class of shares, even though the supermajority have approved, we don't want them to be, for example, this case, implemented in the company. If they give valid reasons, then in this case are so much reasonable to the company, whereby, for example, maybe the minority in that class of shares, when I feel like in this case, their voice hasn't actually been heard, or for example, in this case, maybe their rights are actually having to be violated, then in this case, they can proceed and do what? Maybe petition. If they petition and of course the court objects, then the company wants to do what? Proceed with what? The variation. So in short, if there has to be a variation of class rights, the members of that class of shares will have what? To say something. They'll have to say something. How would they say something? Convening of a meeting, at that meeting, they'll be able to pass a resolution having to do what? Special resolution having to do what? Approve of what? The variation of the class rights. So the company can't just wake up one day and they say they're bargain. The members of that class of shares have to do what? Approve of it through what we call what? A special resolution. That is 75% plus of the voting rights in that class of shares. But you happen to say the minority in the same class, which is actually 15% plus, can be able to petition before the court, give reasons that in this case, they do not want the right to be varied, even though it has been approved by what? The majority in that class, the supermajority in that class. So it means that if they give valid reasons, the court can end up having to do what? Give an injunction or simply stop the company from having to proceed to do what? The variation of the class rights. The class, and of course, the rights have already been able to look at them. The dividends, this particular rates, those are the rights they are going to enjoy. But of course, now in this case, they want to do what? They want to be varied. They want to be varied. They want to be varied. So if that is the case, then of course, that is what will actually end up having to do what? To happen. So, Wanji, you can just be able to take us through that first paragraph section.
Section 3 of the Act states that shares are of one class. Shares of one class, if the rights attached to them are in all respects uniform. The rights attached to shares are not to be regarded as different only because they do not carry the same rights to dividends during the 12 months immediately following their allotment.
Following the allotment. So variation of class rights, you can take us through that particular place A and B. Press.
Rights attached to a class of a company's shares are valid only in accordance with the provisions of the company's articles providing for the valuation of those rights, or if the company's articles contain no such provision, if the holders of shares of that class consent to the valuation.
If the holders of that class of shares do what? Consent to the variation. If the holders of the shares actually do what? Consent to the variation. So the consent required for the purpose of variation is to be given by the holders of a class of a company's shares. Is the consent in writing from the holders of at least 3/4 in nominal value. So 3/4 is what? 75%. 3/4 the nominal value of the issued shares of that class, excluding any shares held as treasury shares, or a special resolution passed at a separate general meeting of the holders of that class sanctioning for the variation. So a special resolution is what, 75% plus. So the holders of not less than the aggregate than 15% of the issued shares of the relevant class, being persons who did not consent to vote in favor of a resolution for the variation, may apply to the court to have the variation cancelled. So the holders of what, this 15% can be able to do what, object. They apply to the court and petition, give reasons that in this case, you don't want these rights of the shares to do what, to be varied. If the rights attached to the shares of the company are varied, the company shall within 14 days after the date on which the variation is made, lodge with the registrar for registration notice giving particulars of the variation. So for example, in this case, if the 15% are not actually objected, then they simply do what, proceed and do what, the variation of the class rights. So if a company fails to comply, the company and each officer of the company who is in default commit an offense and on conviction are each liable to a fine not exceeding what, 200,000 shillings. So that's basically the procedure of variation of what, class rights. Variation of classes. The examiner can ask and put their name in 3 months or maybe 4 months. So you need to be able to remember what you've just been able to say about what class rates, what you've been able to say about what class rates. So reduction of capital. So you can look at reduction of capital. Reduction of capital, very quickly, what actually happens. And the reduction of capital, and the reduction of capital, and the reduction of capital. So just when you want to reduce, inamaanisha nini? Una reduce capital. Kama ulikuwa na 100 million, una reduce mpaka 80 million. So reduction of capital. Reduction of capital. Reduction of the capital. Reduction of capital. This is having to do what? Reduce the capital of the company. It can happen as a result of a number of factors. For example, it could be in this case, you want to extinguish liability on those shares that have not actually been taken up or fully paid up for. You are trying to do what? Cancel out that portion of what? Of capital. Or in this case, you want to cancel paid up capital, which is actually already lost or is actually unrepresented by any what? Available assets. Available assets. Remember, this case probably when you're having to talk about this case raising capital, so you're able to raise capital. You go to raise capital, you raise capital. So for example, the balance sheet, we see now we what? And current assets. Then current assets. So the other side will have capital and those what? Liabilities. So capital is raised here. Capital is raised here. It is raised there. But of course, when you raise capital, you end up having to, for example, invest in what? NASA. You can invest in maybe machinery. Invest maybe in machinery, you can put in buildings, you can put in motor vehicles. You can do other forms of investments. So, but now in this case, the value of the capital, for having to realize, for example, the first value will actually be dependent upon, for example, the assets that the company has. So, of course, now in this case, you've got, let's say, for example, maybe you got 2 billion out of the issue of capital. So that's like maybe 3 or 4 years ago. So you invested in what? In assets. So it could be machinery, but now instead they have already lost value. They have lost value because of what's depreciation and all those. So it simply means that this part of capital, 2 billion, is not actually having to be represented by what? The available assets, because they have maybe lost value. So it simply means you have to what? Reduce your capital because there's no corresponding representation regarding the assets you acquired with what? That capital. So you do what we call what? Share capital reduction. Share capital rest. That would be part of the reason that this the company decides they will do what? Reduce their capital. They will reduce their capital. For example, it could be to pay off any paid up capital in excess of the needs of the company. I'm not going to capital mingi. is actually in excess. So it is just lying here. You know, in this case, when you get capital, is in form of money. Unaiweka wapi? Kwa bank. Siko hapa kwa bank. Iko hapa kwa bank. So imelie tu hapo. Inalala tu hapo. So it is exactly what? In excess. Exactly in excess. So they are not having to utilize it. So what do? They decide we end up having to do what? To reduce the capital we have in the company. So the reasons it could be maybe they want to extinguish any form of liability on unpaid up shares, or in this case, the capital that they are having in the company, there's no corresponding representation with regard to what? The assets. Or for example, the capital that is actually already in existence, it is actually in excess of the needs of the company. So they don't actually need it at that point. For example, in this case, maybe what? The cash flows are actually very high. Because in this case, they can be able to do what? Maybe sustain their operations. So you don't need that kind of a capital. So you end up having to do what? Maybe reduce the capital. So if the company has to reduce the capital, then it should be able to follow the provisions as provided for under the Companies Act. Provisions as provided for under the Companies Act as to how share capital reduction should be done. So number one, what will happen? There'll be a convening of what we call what? A meeting in the company. Lazima wataitisha mkutano ka members of the company. At that meeting, they'll pass what we call what? A special resolution. They'll pass what we call what? A special resolution. That in this case, they are going to do what? Proceed and reduce the share capital of the company. With that resolution, they'll be able to petition, maybe present before the court, that we've decided as a company, we'll be able to do what? Reduce our capital. Reduce our capital. We'll be able to reduce our capital. Then once the court gets that resolution or request or petition for share capital reduction, the court will end up having to list all the creditors. List all the creditors. List all the creditors of the company. List all the creditors of the company. And of course, call upon all those creditors who could, for example, in this case, be intending to object to that share capital reduction, wajitokeze, they come forth and actually say, we don't want the company to do what? A share capital reduction. Once we have, in this case, any creditor having to object, the court will likely call upon the company to dispense of or pay off that particular creditor. To dispense of or pay that particular creditor. Then once all the others are actually okay, the company will be able to go and proceed and do the share capital reduction. It will be given the order for share capital reduction by the court, and the court will be able to proceed. The method under which the company will be able to do the share capital reduction will be at the discretion of the company. For example, they can be able to do what you call what? A buyback of the shares, or maybe consolidation of the shares, like that. They'll be able to decide how they do the share capital reduction. The ones that has been done, the registered company has to do what? To be notified of the share capital reduction that has actually done what happened in the company. So there's something I've been able to mention, that in this case, the court will be able to list who? Creditors. The court will be able to list who? Creditors. So you could be asking yourself, why list all the creditors? Why list all the creditors? Why list all the creditors? So remember, when the company is actually having to raise share capital, it is going to look at something we call what? Maintenance of share capital. Maintenance of share capital. Maintenance of share capital. The company is actually called upon to be able to maintain what? The share capital. It's supposed to maintain the share capital. But you can see we having to say they are going to do what? Reduce. They want to reduce. If they reduce, they won't be maintaining it. Why is it important they maintain it? It is simply because this share capital is normally the fund of last resort to these creditors whenever the company is liquidated. So their fear would be, in this case, they are losing the money they could have relied upon if the company would have been liquidated. Therefore, the essence, the court has to list all of them and call upon them, any one of them who is objecting to this share capital reduction, to this money of theirs. In any case, the company is liquidated. Ajitokeze mbele na aseme he doesn't want what? The share capital to be reduced. Then what happens? We are saying the court will be able to call upon the company to pay off huyo creditor amejitokezea, hastaki share capital reduction ifanyike, ameobject wamlipe pesa yake, wamlipe pesa yake. If all the other creditors are actually okay, then of course now in this case the court gives what they go ahead for the share capital reduction to be done. So it gives out an order for share capital reduction. So that's ideally what will likely end up having to happen regarding share capital reduction. So procedure number one, Grace, you can take us through up to point number 3, up to application for court sanction.
Procedure for reduction of shares capital. Convening an extraordinary general meeting and placing the matter on the agenda before members. The company must pass a special resolution which is supported by the report of the members entitled to attend and vote at the meeting of the company and authorizing the reduction of capital. Application for court sanction. Once the company passes the resolution, it must apply to court by petition for an order providing the reduction, where the proposed reduction involves extinguishing and reducing liability with respect of unpaid share capital event.
Every creditor?
Every creditor of the company is entitled to object to the reduction. The court shall make a list of creditors entitled to object to such a reduction and the amounts respectively owed to them, and then publish it. It will then fix a date on which any creditor who has been included on the list and demand to be included so as to have the right to object.
So as to have the right to object. So wanasema wanapanga list, wanaambia kama kuna creditor yote hataki kampuni reduce capital, ajitokeze mbele mapema. Then the next one, you can take us through the last ones, Wanjiru.
Where a creditor entered the case does not consent to the reduction, the court may, if it deems fit, dispense with the consent of such creditor if the company secures payment of the debts. Registration of the order, registration of the court order confirming the reduction shall be filed with the registrar. The registrar shall then certify the order, then issue a certificate in his name, and the certificate shall be conclusive evidence that all requirements of the Act with regard to reduction of capital have been complied with. Company shall then proceed to reduce its capital and method of reduction to be adopted is at the discretion of the company.
Is at the discretion of the company. So sometimes the examiner can ask, what is the role of the court? Is that question in the past paper? What is the role of the court? What is the role of the court in share capital reduction? So can we see in this case, they list all the creditors. They give out an order for share capital reduction. They give out an order for share capital reduction. So they list all the creditors who can end up having to be entitled to objection. And of course, in this case, call upon the company to do what? Dispense off with any creditor objecting the share capital reduction. Another role they play, they normally give out an order approving for what? Share capital reduction, which is normally filed with the register of companies. Then of course, the company does what? Proceeds and undertakes what? The share capital reduction. Proceeds and actually undertakes what? The share capital reduction. So you can see I've highlighted that area. So when you see I've highlighted, so when you are reading through, you need to be very keen. What is this Malima highlighted here? So it simply means it is a very dangerous manner, either that one. So you must be very careful when you're having to do what revise your notes. When you're going through the notes, just be very keen what is happening there. So we can take a small break. So it is a small break of 5 minutes, and I think we can be able to proceed with raising and maintaining of capital. What normally happens regarding raising and maintaining of capital. Right, so we can start looking at raising and maintenance of what? Of capital. And of course, you also look at the rule in favor versus with what? The rule in favor versus with what? The rule in favor versus called upon under the Companies Act that it should be able to do what? Maintain its share capital. The company should be able to maintain what? Its share capital. So they should be able to keep it intact. They should be able to keep it intact because we've already said that it is the fund of last resort that can be relied upon by creditors whenever the company is having to be done what to be liquidated or is having to be another term we use it what winding up, winding up. And of course, in this case, I had already indicated few achievements, but of course, you can forget about everything about liquidation, but don't forget what happens during liquidation. Comes to an end, then of course, creditors, they are paid their dues. They are paid their dues. And ideally, where this money comes from, it is normally from share capital. In what sense? It comes from capital. In what sense? This is shareholders are investors in the company. They invest into the share capital of the company. Wanapatia kampuni nini? Capital. Hiyo capital tumesema ati haijakaa mahali tu imekaa ina relax, inangoja ati our creditors. When you say in this case it is the fund of last resort, hatumaanishi imekaa ina relax inangoja to our creditors on liquidation. Tumesema wana invest for example in what? Assets. Wana buy machinery, wananunua manyumba, wanajenga nini, all kind of infrastructure is actually invested in. Wananunua for example so it simply means that, in short, when the company is having to be liquidated, if Tuskys has been liquidated today, it simply means that they sell off the assets of Tuskys. Wapate pesa, waanze kulipa nini? Creditors. Ndio wakimaliza kulipa creditors, watakuja waanze kulipa nani? Wakina shareholders. Ndio maana tulikuwa tunasema that in this case, ordinary shareholders will be entitled to the rest of the. So ideally it means, of course, you've invested capital, but it has been put in what? Machineries, buildings. When the company is liquidated, all of them is in our swap. So that's what we're having to say. It is the fund of last resort that can be relied upon by creditors whenever the company is liquidated. So this out of capital is that amount that you utilize to do what? Pay off these creditors. The company is actually called upon to be able to maintain it. Because now in this case, if it happens, they misuse it. For example, if these machineries are not actually well taken care of, for example, they are simply disposed of anyhow, then the money is actually squandered. It simply means that the capital of the company is not having to be maintained. And therefore, the creditors will not actually get their money. In that case, for example, the company is done or is liquidated. So the company is called upon to ensure that its share capital is actually done what? Maintained. And of course, they can go to adapt a number of ways as well. In this case, the capital can be maintained. Ensure when you sell the shares, it is only for money worth. Remember, we said what promoters can be given what? Free shares. But I told you something, it is not ideally for free. They'll have to get money somewhere and of course do what? Replace. We're having to say you can be able to issue shares at what? At a discount. But generally, the issue of shares at a discount is generally prohibited. And also, if in any case, for example, if you issue shares at a discount, you have to get away as far in this case, for example, you'll be able to ensure you cover what? For the discount. We are having to say that in this case, for example, you can redeem shares at a premium, but I told you where you get the money for the premium. Get from the share premium account. Share premium account. So the company should be able to ensure, in any case, it is issuing out shares. It has issued out shares for money worth. For money worth. Lazima watu watoe pesa. Kama umepeana for free, find a way as how you can be able to cover for the shares. Generally, the issue of shares at a discount is normally what's prohibited. In any case, you are doing redemption of redeemable preference shares to ensure the premium in that case is gotten from the share premium account. Share premium account. And therefore, the role in Trevor versus Whitworth, simply lays down further emphasis as to why in this case we should be able to maintain the capital of the company. It simply states that a company cannot purchase, not actually be able to directly purchase or finance the purchase of its own shares. Because that in this case, that and that's what contributes to the what? The reduction of the capital of the company. Failing to do what? Maintain the share capital of the company. A company cannot purchase or finance the purchase of its own shares. So, Grace, you can take us through raising and maintenance of capital. You can just read through the whole paragraph up to point number E, the next page.
The capital of the company, whether paid up or not, is regarded by the court as constituting at least in principle a permanent fund available to the creditors of the company. This capital is required for protection of creditors, since the liability of shareholders is in general limited to the minimum amount of shares taken up by them, and thus only fund of last resort available to the creditors is the issued capital. It has therefore been necessary for the court and the legislature to provide that the full value of that capital be raised and maintained as a fund so far as ordinary risk of business will allow. The following rules relate to the raising of capital. The issue of shares at a discount is in principle limited, as this would mislead persons dealing with the company into believing that the full value of the issued capital has been received by the company. When shares are issued at a premium, the premium is transferred to a share premium account, and this can only be applied for purpose provided by the Act. Payment of shares shall be in money or money swap, and in case of public limited companies, it must not consist of an undertaking to work or perform services. A public limited company may not allow shares until it has received at least a quarter of its nominal value and the whole value and the whole of the premium. A public company may not allot any shares for consideration other than cash without an evaluation report with respect to the consideration.
Yes, thank you very much. So those are just some of these are in this case, the company should actually do what you maintain. So in the next case, for example, you issue out, they're having to say, for example, the last one, a public limited company may not allot any shares for consideration other than cash without an evaluation report in respect of what that consideration. So you cannot actually be able to give out shares for any other consideration other than what? Cash. Other than in pesa. And lazima tupate shares, lazima tupate pesa. Tuweze kumaintain capital. Tumeuza shares, tunataka kuona pesa. Pesa iko wapi? In that case, for example, if it is for another consideration, it has to do what? It has to be given a special, there has to be a special report indicating what is that other what consideration. The point number 3, you can go to the having to say, payment for shares shall only be for what? For money, what? And in case exactly, for example, this is a public limited company, it must not consist of any undertaking regarding what to work for or to perform any other service to the company. Mtu asije kufanya kazi kwa kampuni aseme nataka kufanya kazi then you pay shares. So this is when you give out those shares, then regarding to the free shares, you have to find a way as to this case, you go to what? Cover up for the amount not realized on those shares, because in this case you won't be maintaining what? Your share capital. Yani shares zako zinaonyesha kwamba for example a million shares each ulikuwa unauza na so uko na share capital ya ngapi? 100 million, sio 100 but out of this, let's say for example maybe 50 shares ulikuwa umepeana sare, so 50 shares worth 5,000 umepeana sare, so inamaanisha hii share capital yako sio 100 million, iko less than 5,000. So you are not maintaining it. You're not maintaining it. That's why I'm having to emphasize it must be for money worth. And of course, in this case also, they're having to say number 1. Generally, the issue of shares at a discount is actually what? Prohibited. It's actually prohibited. It's not actually encouraged. It's not actually encouraged. In the case you're having to say you issue shares at a discount, you must find a way as how you can be able to do what? Cover up for the discount. Cover up for the discount. So that just some of the ways, so in this case, for example, you can do what? Maintain the share capital. Further to that, rules governing maintenance of capital can include number 1, the reduction of issued capital must comply with the strict legal requirements, including confirmation by the court, which you've already been able to look at. Court inakuwa involved. Kama mnafanya share capital reduction, lazima court ifanye nini? Ipeane the sanction or the approval. A company will only purchase or redeem shares out of what? Distributable profits, or out of fresh issued shares, not shares to raise cash for that purpose. A company may not issue shares to a nominee of its own. Or what I mean by a nominee here is, for example, in this case, it is already a company they have already been able to invest in. So a public limited company must sell or cancel any of its shares acquired by itself, by forfeiture, or surrender. Then a public limited company may not in principle finance the acquisition of its own shares. The last one, dividends can only be paid out of what? Distributable profits are not out of capital. So dividends can only be paid if the company has realized profits. Is when they can only be able to pay what? Dividends. If they are not realized profits, there's actually a loss. Then dividends cannot be paid. So the company won't proceed to the capital. Won't proceed to the capital. Won't actually proceed to the capital and of course maybe get money out of the capital to pay what? The dividends. It can only be paid out of what? The distributable profits of the company. If there's no any form of realization of profits, it simply means that the shareholders in that particular year won't actually be allowed to what? Get any form of what? Dividends. They won't actually be allowed to get any form of dividends. So the emphasis regarding this kind of maintenance of share capital, it is laid down in the famous case law we call what? Share versus withdrawal. Share versus withdrawal. So the rule, basically the rule under this particular case law simply states that a company cannot end up having to purchase or finance the purchase of its own what? Shares. So it cannot directly purchase. So there are two things that are having to happen. It cannot directly purchase. It cannot directly purchase, or in this case, for example, finance. You know what you mean by having to finance? You simply give someone else the money. Then it does what? Count back to buy the shares of the company. But when you talk about having to directly purchase, it's whereby the company by itself buys them back. So the rule simply states or emphasizes the essence of maintenance of share capital. So the company cannot purchase or finance the purchase of its own shares, So when people can take us through the rule in share versus withdrawal.
The rule restricting the company from buying its own shares or financing the acquisition of its own shares was laid down in Trevor versus withdrawal. In this case, a shareholder sold back his shares to the company, upon which he was paid part of the price. Before being paid the balance, the company went into liquidation and he claimed from the liquidator the balance of his money and the shares he sold back to the company. The claim was dismissed and the court observed that a registered company had no power to purchase its own shares, that the claim was intra-bias. It was further held that the object of the company legislation was to prevent this in order to preserve capital intact. This being virtually the only fund on which a limited company's creditors could rely since they cannot proceed against the private estate of the members.
The private estate of the members. So you can see in this case, this person had done what? So in this case, a shareholder sold back his shares to the company. So he had actually sold shares back to the company, but of course the shares had not actually been fully paid. So it happened, the company was having to be liquidated. So he wanted to do what? To rank as one of the creditors to be paid the due amount. But now in this case, the question arose. And actually in this case, it was claimed the amount cannot actually be paid because the company cannot be able to do what? To purchase its own shares. So this particular rule does emphasize, or places emphasis on the essence of having to do what? To maintain the share capital. Simply having to say it is virtually the fund of last resort that creditors can be able to rely upon whenever the company is liquidated. Therefore, as having to emphasize, lay emphasis on maintenance of the share capital, So the effect of the statutory restriction is to prohibit, so also under the statute, it is prohibited. It is to prohibit any transaction between a company and a shareholder by means of which money already paid to the company in respect of the shares is returned back. So that will be having to do what? Reduce the capital. Money paid already as capital, you are returning it back. You will be doing what? Messing up. Na hizi pesa. Utakuwa mess up na hii pesa. You will be messing up with that money. So of course the rule has exceptions. The rule in share versus withdrawal has exceptions. And of course, they are normally categorized into two. The exceptions are under direct purchasing, where the company can now be allowed. When you talk about exception, in this case, where the company can be allowed to do what? Directly purchase. Then of course, where also it can be allowed to do what? Finance. Situations gani, although tunasema general kwamba in this case, the company is prohibited under the rule in share versus withdrawal. Kuna zile exceptions ambazo hakuna option, itabidi kampuni imefanya nini, buy back the shares. So we have those ones under directly purchasing and those ones are under having what, finance. So you can start with those ones under which the company is allowed to finance. So Grace, you can take us through those ones. You've seen them? Yes.
Providing financial assistance for the purchase of shares in the company. Where a company provides financial assistance for the purchase of the secure shares, where lending the money is part of the ordinary business of the company, and the money is lent in these circumstances, for example,
A bank. So what do you mean by that? What do you mean by that? Unajua bank inapeana loans. So wanaweza kupea loan leo, kesho umerudi kwa stock exchange unanunua shares at the same bank. Because now in this case, the lending of the money is part of what the normal ordinary business of the bank. So it can provide financial assistance. There is that exception because the ordinary business ya bank ni kupeana nini, loans. Hata wakiwa wanapeana loans. Oh, please. So wanapeana loan hivi, so someone else comes and actually buys the shares of the same bank. So that is an exception under which now the bank can be able to finance. Number 2.
Where a company provides money under any of the employees' shares scheme for the purpose of fully paid shares to be allotted to deserving employees.
Deserving employees. For example, on like an employee shares. Tunasema kwamba the company inakuja na scheme. Wanasema those who perform exemplary well, we want them to be part owners of this company. So the company does what? In our pair, chapa, pesa, buy the shares of the company. So you can see they have already been able to do what, finance. But of course, you are having to say there must be an employee scheme. There must be a scheme they have crafted. As for example, these shares will be issued to the exemplary performing what, employees. So when our pair pesa, then one shares like
a loan to employees other than directors, able to purchase shares for the company.
So now in this kind of a situation, there's no scheme, there's no crafted scheme how the employees are given money. But in this case, the company just give out a general loan to an employee. Then eventually does what? He buys the shares of the company. Then the last one.
Where a shareholder receives cash dividend from the company and uses the cash to purchase shares from the company.
Yes. So unapata dividends. Immediately unatumia the dividends to what? Buy the shares of the company. So because the company has been able to, like in this case, indirectly finance you to do what? Buy the shares of the company. So hapo ni penye kampuni inafanya nini? Ina finance. One thing you don't forget is where the company is having to finance. Now in this case, I want you to give us where it can directly purchase of its own shares.
In case of a valid reduction of capital sanctioned by
the court, yes. You've seen the procedure of share capital reduction. Tumesema lazima koti approve. Na koti approve, tumesema company itazinunua tu back at their own what? Discretion. So under a valid share capital reduction, the company can be able to directly purchase its own shares. Unaweza buy back. So our finance wanazinunua tu back directly. They can be able to directly purchase their own shares under a valid share capital reduction sanctioned or approved by the court. Number 2. In case of redemption of preference shares, hiyo inabidi ni explain, sio unajua kwa njia. Tushasoma redemption of what? Redeemable preference shares. I told you to redeem is to do what? To buy back. Number 3.
Fair company to buy or make arrangements to buy the shares of minority shareholders in case of operation to minority.
In case of operation to buy, kuna minority shareholder anaona kwa hii kampuni our majority shareholders wanapeleka. He goes to the court of law because he does what he wants to exist as a shareholder. So in this case, the company is actually called upon wamrudishie pesa yake I exist as what? As a minority shareholder. So they will to buy back the shares. Then number 4.
In case of a valid forfeiture of shares.
In case of a valid forfeiture of shares, whereby the company ends up having to forfeit or cancel out shares for non-payment of what? Forms. In that case, for example, they agree under the articles, CIFA, they already acquired shares. Then the last one.
In case of a valid surrender of shares by vendor.
Yes, someone just validly surrenders. And of course, the company agrees they end up having to what? Buy back the shares. So that's the rule in CIFA versus which what? That is the rule in CIFA versus Whitworth, they won't be Trevor versus Whitworth. Trevor versus Whitworth. So I want us to look at some past paper questions. So these are the parts we'll finish later. So we don't have to look at right now. I want us to look at some past paper questions. Let me see. So look at December 2022. December 2022. December 2022, question number 4B. Question number 4B. You see it?
Explain the following types of share capital.
Yes. So you have paid up capital
And issued share capital.
and issued share capital. So paid up share capital and issued share capital. So I think if you look at our notes, check under types of capital include yenye iko ni paid up. Paid up ndio hatuna.
But the paid up, from other capital where there is paid and unpaid.
So paid up, just from the word itself, paid up is share what. So it's part of that, part of the share capital, part of the issued share capital that has been subscribed for and actually paid up for by the shareholders. It has already been paid up for. Then issued is that part of the nominal or registered capital that has been issued out for subscription or for application by members of the public. Yeah, so that's how we can be able to describe them. So I think question number, there's a question we've already looked at here. I don't think we need to, we think we have already looked at it here. Describe 7 reasons why shareholders' membership in a company might be. Question number 3 again. You've seen it. Might be terminated. Then highlight 3 items that form the content of members of a register of members registered in a company. This is also that we have looked at it. Then let's see this one. Brian is a preference shareholder in 𝐂𝐿𝐿 Company Limited. He is entitled to a dividend of 11%. The company has, however, been suffering losses and has passed a resolution in general meeting to reduce the dividends preference to 7%. So advise Brian on his rights as a preference shareholder and whether the company can grant the dividends he may be given. So what are the rights of a preference shareholder? Right to? Right to vote in general meetings, but I want to
yeah, they have a preference.
In terms of what? Dividends. So to tulisema wako na right of they have a right to get dividends, the right to get dividends before any other class. Dividends before any other class. Before any other class. Alafu pia tukasema their dividend is at what specified rates. Is a specified rates. Another preparation treatment. Kampuni ikiliquidatiwa
Before any
other class. Receive right the residues. Yani mabaki ya kampuni. Right the residues of the company on liquidation before any other class. Then their dividends is what accumulating. Their dividends is what accumulating. Kuna kitu kama hiyo. Accumulating. Ingine siko hapo tu kwa hiyo handout ya shares. Naweza hata highlight hapo to stated in you highlight indicate there. So sasa kuna so they're asking whether the company can value the dividends he may be given. You think the company can value? Given. Yes, do you think they can? But the sum.
steps, there are some steps that have to be taken.
Which ones?
The convening of a meeting.
Give it for each. So first they want to do what? Vary the rights of this member. Of course, I'm able to give you the procedure for what? Variation of class rights. So simply tell brand, yes, of course they can be able to vary. They can be able to vary, but of course now in this case, you together with other members of the same class of shares. The members of the same class of shares should be able to convene a meeting whereby also they can be able to pass what? A special resolution for approval of what? In this case, the variation of what? The dividends. But any minority shareholder, for example, in this case, if Brian is actually a minority shareholder, he will be entitled to petition the court for objection of what? The variation of what? The dividends. If the court actually approves of it, the company wants to do what? Proceed with the variation. But if all is actually okay, the special resolution has actually been passed without any form of objection, then of course the company can end up having to do what? The variation of the dividends. So remember that procedure. So you can be able to go back to your handout and just indicate under share capital. It was stated well, December, it is here. So it is under class shares and variation of class rights. Indicate there December, question number 3, part C, Roman 2. So that when you are going through the handout, you'll be able to see This is an area I need to be keen with. You've seen that place, classes of shares and valuation of class rights. You have the methods of issue of shares. You have the methods of issue of shares. You need to remember the steps. That's why I told you the examiner can test. You need to remember those steps for variation of class rights. I think it is 3 times in the past papers. It has been tested in 3. So this sitting, there's another sitting it was actually tested. Now that one was just direct. So how can the company vary the class rights? How can the company vary the class rights? They wanted to explain that kind of what a procedure. Can look at April 2022. April 2022. What you can read for us question number 1, A and B.
And then, 6 ways in which a person might become a member of a company.
Part B.
Identify contents of particular register with respect to a company beneficial or
For companies beneficial or
okay, question 1 say a person dealing with a company is entitled to assume the absence of facts, putting him in doubt that there has been due compliance with all matters of internal management and procedure whereby articles of obligation with reference to the rules in the oil British Bank versus Chapel summarize 5 exemptions to the above statements.
Thank you very much, Wanjiru, for having read to us so well. So ways and how you can become a member of a company. Grace. Transmission of shares is correct. It's correct, yes. Subscribing to the shares on allotments or direct offer. When the company does a direct offer or direct allotment, and it's correct. Transfer of shares. Transfer of shares. Of course, transfer of shares, I told you, transfer and transmission appears in what? In both. Cessation and becoming a member. So kutoka leo inakuwa tu unatembeanga kwa kichwa hapo na transfer transmission na mwanga kwa zote mbili. But of course, and in this case, cessation, transmission, what na break into 3, tunasema yes, insanity, bankruptcy. So transmission transfer appears in both. And of course, in this case, under a direct offer of shares or allotment of shares. Another way. Yes?
Qualification shares.
Very brilliant. Very brilliant. Taking up what we call qualification shares. Grace, tulisema sasa hivi utakuwa appointed director wapi? Safaricom. Utakuwa called upon kuchukua some shares in the company. Tunaziitaje qualification shares. So when you take up the qualification shares as a director, you become a member of the company. Another way. receive employee shares. You receive employee shares. So that less. Let say it is under direction of so there are a number of ways. There are a number of ways you're having to say, for example, you could end up having to be like an employee. For example, that one under qualification of shares, you become a director. But maybe that one we can be able to place it under what maybe direct offer. And we do a direct offer. In this case, you are given the offer as an employee to do what? Take up the share. So you also see another way is through what? Subscribing to the memorandum on formation of the company. Through the doctrine of 𝐿 in the register by expect. Then of course, in this case, you continue to do what? Enjoy the rights as a member of the company. So tumesema ngapi? Hiyo sasa hii nafasi kuanza kutembea nazo kwa kichwa. Transfer, transmission, taking up qualification, shares, subscribing to the memorandum of association and formation of the company through the doctrine of 𝐿𝐿. Through the doctrine of 𝐿𝐿. Then of course, in this case, by having to do what? Register as a member of the company. This is, for example, in this case, you apply to register as a member of the company. Simply mean, for example, in a private company, whereby in this case, you want the shares to be transferred into your name, or you want to become a member of that private company. So, for example, in this case, call upon to be registered as what? As a member of that particular company. So those are just some of the ways, but you can go check out under the notes of membership, which is the pattern. So, part B, identify 4 types of particulars to be registered with the respect to the company's beneficial owner. Yeah. It is the last thing, yes. Number 1.
Beneficial owner. Residential address of each beneficial owner. The date of birth of each beneficial owner. The percentage of ownership or control that each beneficial owner holds in a company.
Yes.
There is another one, a description of data of control that each beneficial owner has over the company.
Over the company. But still, if you check the notes, soft copy notes under membership, the last thing, the soft copy notes under membership, the last thing, register of beneficial owners. The last thing, register of beneficial owners, but still I agree. I dictate that to you plus. Then this one, a person dealing with a company is entitled to assume, in absence of all the facts putting him in doubt, that there has been due compliance with all matters of internal management and procedure required by the articles, with the reference to the rule in Royal British Bank versus Taiwan. Summary to the exceptions to the above statement. So this is one of what the majority. This is one of the major case laws where in company law, which I told you in this case, you must never forget about it because it has what exceptions. It has what exceptions. So when you unaweza sema moja.
So in case there is
forgery is correct. Forgery, in case of forgery. In case of forgery, for example, in this case, if there's a party within the company having to deal with third parties and they approve documentation for what? Forgery. So in this case, it simply means that the third party won't actually do what's be protected. So you can be able to see the exactly what forgery, apart from forgery. Negligence on the outside. Negligence on the outside. If the directors acted beyond what their apparent authority. Yes. If the third party, you can read for us just all of them, but you can check under you've seen the regress. Topic number 2. Just after articles are embedded, the last thing under topic number 2. Doctrine of constructive notice. After hapo, umeipata. Rule in Royal British Bank versus Taiwan, the indoor management rule. After articles 2 up on them.
Before membership.
Just before membership. It's like the last thing under that topic. Importante. Kwani Grace unaangaliaje? Bullet. So they are there. So continue unaweza kupea number 1.
Yeah. So if the third party had knowledge of irregularity, if there is a forgery involved, negligence on the part of the outsider, and its failure of duty of care, no knowledge of the articles and acts, Service Act, beyond the powers or authorization under the Articles Association.
That's bias. In this case, the directors, for example, acted beyond their apparent authority. They acted beyond their apparent authority. So those are the exceptions. If you could have been able to put there, then because you could have been able to score the mark. So the exceptions to the rule in Royal British Bank versus Chapman. But sometimes they call it what the indoor management rule. The indoor management rule. So this is how is okay laws. I can like 100% guarantee you, moja itakuja by this coming season. And 100% guarantee, moja itakuja. Yes, it just explains. In fact, now the question you explain the 5 of them, and of course, for not Zikotan press. Yes, so they explain to his range that is for the marks. In case of a forgery, in case of negligence on the part of the outsider, knowledge of the articles, directors acting beyond their apparent authority. Yeah. So So of course, kuna hii parts. Now question number 2C. Inasema highlight 6 rules governing payment of what? Dividends. So it's the next thing that you'll be able to look at. You can just highlight in the handout. There's that part of dividends. So indicate there it was tested in April. It was tested in April. Please.
Yeah.
So just indicate that it was tested. Yes, question number 2C. So I don't want us to go through it right now, but I think we'll go through it next time. Maybe let me get we can look at question number 6. Question number 6. Let's have a look at question number 16. It says distinguish between a private and a public company. So ilikuwa marks ngapi? 4. So private and a public company. So how do you distinguish? One distinction. Transfer.
Transferred.
Number 2.
So the membership in a private company, the minimum membership, the minimum membership is 1 up to maximum is. Oh yeah.
Maximum is what about a public company?
Minimum is
And maximum.
No maximum. No limits. Yeah. And then use of accounts. In a private company, it's not mandatory like publish, but in a public company,
Mandatory to publish
mandatory.
the books of accounts. Directors,
Directors, yeah, in a private, you can be just one.
Director.
Yeah, one. In a public company, at least two.
directors. Very correct. Very correct.
Yeah.
Very correct. What about asking people to subscribe for shares?
And so, public, private, they don't call members of the
They
company.
cannot invite.
Yeah, members of the public to subscribe, but in public, they normally call members,
Invite them to public to
To
subscribe
subscribe.
for the shares to raise what? Capital. Yes, do your best and but the other is that what time. But it is in topic number 1. So who may it is or not the topic number ujaribu kuzipitia. So now I don't want to test. Usipitie sasa upitie hizo, they can test. So I think we can end there. So let's end there. We look at these other things. So we wind up on this topic. So I'll come with the next handouts. Next topic is debt capital. Next topic is debt capital. I think we are moving on so well. So we will go the same pace, seeing ourselves by end of next month with the stars. We go the same pace, seeing by around end of July, then we can spend around 3 weeks having to revise. So we find yes.
It's really good, auditor. So they say everything we covered, just there.
What topic auditors? There's a topic known as auditors in company law, but you say what tunagusa sana. Under the topic of auditors, the topic number 10 is we just understand who is an auditor in a company, the rights of an auditor. We look at the rights of an auditor, the duties of an auditor. We look at his appointment and removal. After they'll give us an next who is an auditor, how is appointed, duties, rights, removal from office, and of course how briefly just how the auditor are appointed. So we won't actually go into it, but you just want to know who is an auditor in a company because he's a special kind of an officer in a company. So you'll be able to know who's actually an auditor in a company. But we won't delve deeper into those issues that happens where under the under auditing and assurance. Ambapo tuna delve deeper kabisa anafanyanga nini, anafaa kufanya nini. So we won't go into those. Unafanya events gani? Wewe unafanya ngapi? 3. Unafanya law? Financial reporting. Unafanya audits, company law. And the FR. So Abraham anafanya 6. Pole. Hata doa. Only 3. So sema alikuwa ameambia watu 6. People na change.
Yeah.
Akaamua pole. Kuna mbio. Sometimes the syllabus, the syllabus is a bit wide. So there's a lot to cover within a very short time. They're not so well prepared, so they can overwhelm you.
See, when the time 3 months,
It's very short.
It's
It's very short. So people can have a good evening. So we catch up, I think, next week.